Hello everyone, I'm Dwight Mitchell, the founder of Family Preservation Foundation. Welcome to our Child Protection Series Pro Se Help Kit. This video series that we're going to go through today, the session is called EPC Hearing Through Disposition. I hope you enjoy the content and it allows you to better understand your rights and options while you're dealing with CPS. For those of you just joining us for the first time, after a 22-month battle, I successfully defeated Dakota County Social Services in Minnesota and got my children returned to me. Although filled with anguish, it was an education to say the least. And what I'm hoping to do in these video educational series is to pass along the benefit of my knowledge and lessons learned while cross-referencing the Minnesota state statutes, case law, and showing you to what you can find easily on Google Scholar and also other websites. One of the disclaimers that I have to make before each video session, I have to advise you that I'm not an attorney, I'm not licensed to practice law, nor am I providing legal services. My video series is for educational purposes only. I implore you to look at my video workshop, Working with Your Attorney. This is a very important unit in our series and will assist you in not being misguided like I was by my attorney's legal strategy, incompetence, and or greed. Every attorney has their own legal strategy, and I put together a document to what I hope will allow you to have a better working relationship with your attorney. So, as I stated before, this video series is for education only. I will go over the beginning, the middle, and the end of the CPS process and what you can do in your defense against your fight against CPS. This will be hard work, as I have stated in every single one of my series. Nothing easy ever comes free. I'm going to give you like templates to talk about state statutes, talk about case law, but you have to put it all together for yourself. You must create your own court filings in a pro se capacity if you don't have a lawyer. Pro se in and of itself means, for yourself, for you, for me, pro se. So you're not allowed to go into court and say, well, so-and-so told me to say this and so-and-so told me to do that. The judge is going to be like, well, so-and-so's not in court. You are. You have to be doing this for yourself. So you need to understand what's going on. And if there is a question, you have to be able to answer it. You just can't read something and not be expected not to get questions asked. So you really do need to understand the entire process. So it's going to be a lot of reading and late nights, but you're doing it for the best cause in the world. You're doing it for your family and an effort to get your family back. So let me give you an overview of the emergency protective care hearing through disposition. It's going to be kind of a long video series. Most of my sessions are between 30 and 60 minutes long. This one will probably be on the longer side. I always give a rough guide. I can never tell you how long it's going to be. It just depends on how quickly I go through the information or what I think of as I'm talking and giving examples. With 7,000 members, I've seen and read and heard so many different things, but I want to make sure that I'm only giving you specific, pertinent information specific to this topic. So I'm not going to digress and go off track too much. I'm going to pretty much stick to this topic throughout the entire session. So to get started, most of the time, well, not most of the time, all of the time, you're going to get a notice of removal. If a child is taken into custody, the parent or the guardian, whoever is responsible for that child, they find out who it is and they send a letter for that parent or guardian to come to court. So this generally happens on an emergency removal basis or when they think that the child is in serious harm. This notice of removal is Minnesota Statute 260C.176, subsection 1. One of the things that you should keep in mind is that once a child is removed, there is no guarantee that a child will be immediately returned to your custody. The police officers have the ability to hold that child for 72 hours in protective care or custody to assess the danger or threat level. And if they feel that nothing is wrong, they will give you the child back. Or if it was a misunderstanding or an oversight, you'll get the child back. So, but as I said, there's no guarantee of an immediate release. So when a child is taken into custody by a peace officer under 260C.175 subdivision 1, the release can be authorized by the detaining officer, their superintendent, the captain, or anything of that nature, or social services. Sometimes they'll call social services to come on board, and social service can conduct an assessment and decide, nothing is needed, or they can do a safety plan. So those are just some of the things that can happen once your child is removed. The next thing that generally happens is called a pre-hearing detention. So if all the members that have been involved with FPF, our group so far, everyone I've spoken to, they've never had their child immediately released, including myself. So while it is possible, I don't know anyone who has actually gotten a child released immediately within the 72-hour training. And the reason for that is the Title IV funding. So look at our video series, our session on Title IV funding. That's one of our training units, and what triggers these removals. And then you'll have an understanding of why no one gets their child released quickly before that EPC hearing. So here's what happens. EPC stands for Emergency Protective Hearing. So if the child is taken into custody, by law, they have to have an emergency protective hearing within 72 hours of the time the child is taken into custody. That doesn't include weekends. So Saturday, honeys, and holidays don't count. And that's Minnesota Statute 260C.178, subsection 1A. So what happens is that at the EPC hearing, it's called an initial prima facie showing. And what prima facie means, it means at first look, or on its face, without having any facts, without having done an investigation or anything of that nature. They're like saying, well, on its face, this looks like maltreatment, and although we haven't done anything yet to corroborate that or to substantiate that, that's all we have to do in order to remove your child. If we think it is, and we can put together why we think it is, then that child can be removed. If the CPS fails to establish a prima facie case that the child is in need of protection or services, the court can dismiss that at that time. I don't know of anyone that's actually happened to. While it can happen, it generally doesn't. The court errs on the side of caution. So most of the judges will, to me, rubber stamp the social worker's petition and give the social worker time to prove her case. Unlike in other states, for example, New Jersey, where they can't remove a child unless they clearly substantiate the allegations, and they have to go to court with evidence asking for removal. So it can't be just some Joe neighbor calling up, making an accusation, and your child being removed. But you can do that in Minnesota. So with the judicial determination of endangerment, the court has to determine that a prima facie exists, that the child cannot be immediately put with anyone else, and that the child will be in immediate or imminent danger if the child were to stay with the parent or the care holders or their guardian. So technically, the child's health, safety, or welfare should be in immediate danger for this to happen. Minnesota standards are so low that they don't really follow that. I mean, I'm not going to go into that in detail. As to the why. The why is state funding, but how it's going on for such a long time is something that's sort of confounded me with everything that's come to light. It's like a money making machine. It needs to be completely revamped, but I'm not going to get into that right now. So unless there is a judicial determination, as I said, which I never heard of, the child must be released at the time of that 72 hours. Now, you do have the right to come to court with documentation, with evidence, with people at that EPC hearing, and the judge must hear you and must read and consider your evidence and determine whether that child should be released or not. So if there's any reasonable doubt that the child's not in need of protection or services, the judge is supposed to release you. That's Minnesota Statute 260.178, subsection 1B. Like I said, in my humble opinion, if you're in court at that EPC and CPS has filed a petition, unless you have written documentation that clearly refutes what the doctor is saying, or what the social worker is saying, it's very difficult. I mean, I've worked with parents. I've been on cases where I brought in evidence and documentation, and the judge still went with the social worker. It's a hard standard to get past. If it's contrary to the welfare of the child, the court may order the continuance of the child in foster care after the 72 hours. If they feel that the child will not be safe with the parent or guardian, that they'll just say, okay, the child will continue in foster care. And that's Minnesota Statute 260.178, subdivision 1F. The judge also makes explicit individualized findings that continued custody is in the best interest of the child. When you get things back, this relates to, again, to the state receiving Title IV funding. At that first hearing, if the judge finds that the child is in need of protection or services, it triggers the Title IV funding immediately. And if the judge doesn't find it in that first hearing, then it takes longer for the state and the county to get reimbursed. So, as I said, there is no incentive for them to let that child go, immediately, and they generally don't. Out of all of the parents that I've talked to in our group, we have about 7,000 members, and we took a poll. No one got their child released, at that 72-hour EPC hearing. Indian Child Welfare Act, ICWA, that comes into place also at the time of the EPC. If the child is Native American, the court has to make a determination whether the child should be in state court or Indian court and tribunal court. And if the child is of Indian descent, the child is to be transferred to the Indian tribunal court. And that's Minnesota Statute 260C 178, subdivision 1E. Technically, the social worker is supposed to make reasonable efforts, active efforts, to ensure that the child needs to be removed. The court has to find, again, a finding that the social worker has made reasonable efforts. What I found in my case and in all the cases I've been to, it's like the judge parrots exactly what the social worker says. The social worker says, well, I made reasonable efforts, and the judge says, well, the social worker made reasonable efforts. The judge never asked the social worker, well, what reasonable efforts did you do? Who did you call? What did you try and do? Never happens. The social worker puts in this blanket statement, and the judge reads it back. Well, I find that the social worker made reasonable efforts. It's this comedy of errors. It's tragic if it wasn't so true. I've seen it time and time again. It's the same parroting in all the petitions. It's the same parroting in all the judges' findings and all the judges' orders. In my humble opinion, they're all in cahoots. But let me stick to the topic at hand here. So, once the court finds or that reasonable efforts have been made to prevent the placement of the child in foster care, reasonable efforts, then the judge turns it back over to social services, and the child is retained in foster care. The court has to enter that finding in order to get the Title I 4A funding, which they do on a continual basis. And it says that child is in need of protection or services. If there are no services that are made available, if they don't give you a safety plan, or if they don't do all the things that are supposed to do by state statute, they get away with it anyway. It's very difficult fighting with the government. It's very difficult trying to ask the court, well, what reasonable efforts took place? What did they do? What did they do to prevent placement? What did they do to do reunification? What reunification efforts has been tried? Nevertheless, the court always authorizes the removal of that child. It's rare that the child actually stays at home. A bypass case is a case in where you have a child that's already been taken, and so you already have a determination of maltreatment, or you do egregious harm. That's like a bypass. So like if you do like murder, manslaughter, felony, sexual abuse, all of those are bypasses where they don't have to go through the normal channels. They just automatically take the child into foster care right away as part of their judicial findings and judicial determinations. So if the child was abandoned, say they left the child out, or abandoned the child, well, that's another situation of a bypass case. So that's an example of a bypass, and that's where they don't have to go through the reasonable efforts of reunification or to keep the child in the parent's custody. So if the court establishes that the petition makes a prima facie showing that one of the above circumstances exists, then the court can do what is called a bypass case. So the next thing I'm going to talk about is a parental visitation. If the child is taken into the custody, by Minnesota state statutes, the parents are allowed to visitation. That's Minnesota Statute 260C.178, subsection 3B. So as soon as a child is placed into foster care, a visitation plan should be put together. That is unless they feel the child would be in danger if the child saw the parent. So if the court feels that the parent or the guardian would be a threat to the child, then and only then can they revoke visitation. But then they have to have a showing of cause as to why there's an exception for that visitation. They can also do what is known as like limited contact. And limited contact is when the visitation is supervised and it's conducted by the agency. It's like on a day-to-day basis to try and see where it's going to go. When I say where it's going to go, visitation, like if it's hostile or something of that nature between the parent and the child, or if there was a lot of physical abuse, or if the parent and the child aren't getting along. So when it's in the best interest of the child, the agency may ask the court to defer the development of a visitation plan until they feel it's a better time. Also, if you're a father but you haven't taken a paternity test, they might defer visitation for the father until they can establish with the paternity test that you are in fact the father of the child. After they do take a child into custody, they do something what's known as a relative search. The timing is that it generally happens like right away, where they're trying to find relatives in case they have to keep the child in out-of-home placement. It used to be they would wait until after they made a determination or after the child was found in need of protection or services. But now they do it simultaneously. So when they take the child into custody, they call themselves doing a relative search at the same time. And I'm like, you haven't even made a determination. We haven't even made a trial, and you're doing a relative search to find out where to put the child. So that, that's kind of backwards to me. That's a waste of taxpayer money, but that is what they do. So what the social service agency will do is within the first 30 days, they're doing a relative search looking for relatives in case they have to place a child in long-term care with a relative. One of the things they don't do is that they don't put the child with a relative for foster care if the relative is out of state. 9 out of 10 times when I talk to all of the parents in the organization, they say that they didn't, their children were never put with relatives. Mine weren't, and when I talked to everybody else, their children weren't put with relatives. But when I found out using the Freedom of Information Act, once I started looking at it, I said, well, if they put the child with relative, the Title IV-E funding doesn't kick in. And so how they make it more difficult is they say, well, it has to be a licensed child care provider. So it's this false pretense of doing this relative search when they know good and well they aren't going to give the child to the relative in the first place. The relative has to go through a background check. They got to do a home visit. They have to do validation. All of this takes months. And while they're doing all this, the child is sitting in the foster care and the state is getting money back. So if they have to put the child with a relative, well, the state gets no funding from the government for putting that child in with the relative. So if while they're doing the relative search, if you refuse to identify the father or the relatives, they have this way of saying that you're being uncooperative. So the court may order the parents to disclose the names, addresses, and telephone numbers in the court order. If you don't, you'll be said you're in contempt of court. That's Minnesota Statute 260C 178 subsection 1J. So some people will say, well, I'm not going to tell them, and the court could order you to tell them, and if you don't tell them, then they're going to put you in jail, and it just makes it, a bad situation worse, is what I say. You can give them the names and address of the relatives. In my humble opinion, it really doesn't hurt, since they never give them to the relatives anyway. Not trying to be cynical, but I'm just stating my perception, which is my reality. So when the court has ordered the child to be placed into foster care or a non-custodial parent because of mental health, chemical dependency or something of that nature, they have to do these evaluations, these assessments. One of the things that I try and emphasize and stress to parents and all parents, and I say this in almost all of my sessions, you are due a trial in 60 days from the time they remove your child. And in 60 days, they're supposed to have a trial where the county comes with evidence to prove the maltreatment. Don't do anything until then but visit your child. If you don't visit your child, they'll try and use that against you, saying you abandoned your child. So whatever you do, make sure you visit your child at all costs. But don't do anything else. Don't sign any paperwork. Don't agree to services. If you agree to services, it shuts off the 60-day clock and you don't get your trial. Because then they'll go into court and they say, well, Your Honor, the parent is working with us. We're going to postpone, the trial. Well, no. Now they've gotten away with keeping your child, keeping the Title IV funding. Your child's in foster care, and you don't get your day in court. That 60-day can go from 90 to 120. Don't cooperate. Say, I want my trial, and keep saying that. I got a trial in 60 days. That's what I want. I'm not doing a case plan. I'm not doing any services. I'm not doing evaluations. I'm not giving you permission to do anything. I'm not signing any documents outside of visitation. Let's go to trial and prove your case. And so that's what it's really all about, And I try and get people to really understand that. I say that again and again and again. If you take nothing away, just read the state statutes, read what I've just given you, and it will tell you you do not have to comply or do anything with a case plan. The social worker has to create a case plan. That's her job. She can create it. You don't have to be involved in it. she's gonna present it to the court. Fine, just say, where's my trial? And don't say anything until then, but just do your visitation. They're gonna say, well, we want to check your medical records. We want to check your background. We want to check your mental health. We want to do a blood test. We want to do a drug test. No, 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 no. You don't have to do any of that. They have to prove you're a drug addict or whatever it is they're trying to prove. You guys go and prove it. But I'm not helping you do it, and I'm not giving you my permission to do it. You got to go collect it however you can do it. And a judge can't order you to do it either. A judge might say, well, I order you to comply with social services. I'm like, well, Your Honor, help me understand. Are you telling me to sign this against my will, my free will, under duress, and by court order? And the judge is going to back up. No, because he can't do that. That's against the law. And if a judge does do that, say, well, Your Honor, I respectfully decline, because that's against the law. You can't force me to sign a contract or an agreement. So keep that in mind also. What happens next is called the admit-deny hearing. During the admit-deny hearing, and this is a timing thing also, look at my CPS timeline episode that I did earlier that talks about the timing. So the admit-deny hearing has to be within 10 days of the EPC. So after your EPC hearing, you're going to have a separate hearing for admit-deny. And it's very important because between the EPC and the admit-deny, you can file a motion to dismiss and submit evidence to the court as to why your case should not continue. And it has to be done before the admit-deny. I tell everyone, do not do the EPC and admit-deny together. Take your 10 days, write up a defense, write up your opposition to the petition, put in your facts, have your attorney put in a motion to dismiss, or you put in a motion to dismiss, and then you move forward from there. I'm not saying the court is going to grant it, but take the opportunity and file it anyway. In ICWA cases, the Indian Welfare Children's Act, if the child is of Indian descent, then at the same time, they have 20 days to do their admit-deny hearing, because usually they have to transfer the child from its current foster care setting, to an Indian foster care setting. They have to contact the Indian courts. So they give them 20 days for their admit-deny. As I explained, if anyone ever talks to you about combining the admit-deny hearing with the EPC hearing, that's no. So if you're following along in my PDF template, handbook with this videotape, you'll see I have that in red, and it says never combine your admit-deny hearing with your EPC. You must file your appeal prior to your admit-deny hearing. So I have that called out in red. So at your admit-deny, who admits and who denies? A parent who is a party to a part. Let me get that right. Slow down, I'm talking too fast. A party who is a party to the case or a legal custodian shall admit or deny the allegations set forth in the petition by the social worker. Well, you have to be not too sharp to admit to anything, especially something that they have to prove. So again, in my PDF in big red letters, I have always deny everything. The judge will schedule and make CPS prove the allegations within 60 days. I tell everyone, you have 60 days to wait for a trial, or if you try and work on it or talk your way out of it or talk your way through it, it's going to go from 60 days to a year, because they can keep that child for a year. So, I tell everybody, if it was me, roll the dice. I roll the dice. I'm like, I'm not doing it. Knowing then what I know now, because at first I was fighting. And then I said, I want my trial. And then my attorney, talked me into, you'll make it easier on yourself if you just cooperate and do what they tell you to do. And And I did this, and they had my child for 22 months. So I tell everyone, never, ever admit, never work on anything. Stick to your trial. Take your chances at 60 days. Bring your evidence in. Let them bring their evidence in. And then, have the determination made at that time. So if you put in a denial, a written denial is put on the record for the court on the statutory grounds set forth, of why you are denying it. It's entered by your counsel. If you're pro se, it's entered by yourself. And then the court will schedule a pretrial hearing, and then the court will schedule a trial after that. Once that's done, you get what's known as a scheduling order. The court has to issue a scheduling order. That's when the trial is going to take place, when the pretrial is going to take place, within 15 days of the admit-deny hearing. So if you don't get a scheduling order within 15 days of the admit-deny hearing, you can, call the judge's chamber, send a letter if you're pro se. If you have a counsel, your counsel has to say, we didn't get the scheduling order. And the order has to include the date or the deadline of the pretrial, the date of the trial, permanency, progress review hearings, because you have to have those in that 60-day window, the date for filing a permanency petition based upon when the clock started, and the date of the admit-deny hearing on the permanency petition. So all of these things should be in the scheduling order that you get 15 days after the admit-deny. Adjudication. This is another timing issue. If after 60 days you're at trial and the social worker is able to prove their case, and the court makes a finding that there are statutory grounds set forth in the petition that the child is in need of protection or services, then the court will then order you to follow the case plan. Unless you have voluntarily agreed to do the case plan ahead of time, under the false premise that the social worker has said, if you start the case plan now, you'll get it finished that much sooner, and then you'll get your child back. False, wrong, no, don't do it. I don't care what they say. I don't care if your social worker says it. I don't care if your attorney says it. Don't do it. Look it up. Read it for yourself. It's in black and white. If anyone tells you otherwise, they are not for you in your cause or your case. I don't care what it is. I don't care what you've done. Make them prove it in court. So if you admit to services, they can withhold the hearing, they can withhold the trial, and then they'll say, okay, well, you're working on your case plan, so instead of having the trial in 60 days where they have to prove it with facts, we'll have another hearing in 90 days, which is 30 days longer than your 60-day trial. And then they'll say, well, we'll decide at that time whether we're going to dismiss the matter because we feel there's no reason to go forward, or they're going to say the child is in need of protection or custody, or the court, and the court's going to enter a disposition. Out of 7,000 people, I haven't talked to all of them, but I've talked to a lot of our members. Not one person got their child back in 90 days. Anybody that cooperated, it just didn't happen. It just goes on and on and on. There's always some reason, always something that the parent didn't do that causes them to keep the child in foster care longer, which keeps the cash registers ching and ching, 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 which keeps them billing the federal government. So, that's just my reality. I could be wrong. It's my opinion. It's only my opinion. And I'm only relaying the things I've heard. You can call it hearsay. You can join our group, talk to the other members in our group. Look, maybe some of them could share some of their documentation and paperwork, but it's up to you. You're a pro se, unless you have an attorney. Even if you have an attorney, don't do it. Say, we're going to trial in 60 days and need to prove their case against me in 60 days. We've taken on cases like, if anyone knows about the Amanda Weber case, we did it just this way, didn't sign anything, made them go to trial in 60 days, and Amanda got her son back. So I'd like to be able to do that for everybody, but lawyers' trials are expensive. We need our own counsel for our own foundation, and until we can raise enough money to get our own in-house counsel, I'm doing the best I can by making these video series to educate you and make you aware by giving you the state statutes. So as I was saying, the out-of-home placement plan shall be presented to the court within 30 days, and that's Minnesota Statute 260C.178, subdivision 7A. The social worker has to give it to the court. You don't have to sign it. Now, when it comes to putting together that safety plan, technically it's supposed to be the social worker, the parent or guardian, the foster family, the child, and whoever else is involved in this. But, I tell everyone, don't sign that safety plan. That's you agreeing that there's something wrong and you need a safety plan. Say, I won't sign that. If the judge finds that in favor of CPS at my 60-day trial and says now you got to comply with the safety plan, that's when I sign a safety plan. Don't let them tell you this is just perfunctory. This doesn't mean anything. Don't sign a safety plan until after the trial. There's something else I'm telling you. That's free of charge, So if they do find your child in need of protection or services, they're supposed to develop the safety plan jointly with you in mind. And when I say jointly, they can't tell you to do a blood test, and the blood test is an hour away twice a week. That's clearly unreasonable. You can't do that and work. And they can't make you do something. We want you to go to the doctor at 12 o'clock every single day. I can't do that. I'm working. So they're supposed to do this jointly to a point where you're successful, and the whole purpose of the plan is supposed to be reunification. So they're supposed to be trying to help you reunify. Most of the people I've spoken with have told me that they did not participate in the development of their safety plan. The safety plan was put together by the social worker, given to them and said, here, sign this. And most of the people will sign it without reading it. And I tell everybody, well, you're not supposed to, sign anything without reading it. And don't agree, because if you sign it, that means you're agreeing to it. So I'm not going to sign it unless I agree to everything that's being said on the safety plan. They may tell you to take, a drug test or a chemical dependency test, and you're not even there for that. You could have spanked your child, and they could have you doing all these other things that had nothing to do with what you're doing. So, keep that in mind also when you're looking at the plan and you're developing the plan. You have a right to have your attorney there with you when you're doing the safety plan. So you have a right to counsel, and your attorney should be there when you're developing the safety plan also. So, keep that in mind. They're supposed to be advocating for you when they do the safety plan. So if you participate in the safety plan, make sure you agree. And if you don't agree with it, then you have the right to go before the court and tell the judge, Your Honor, this, I don't agree this. The social worker is trying to do this in the safety plan or the case plan, the out-of-home placement plan, any plan they're trying to put together. You can go to the court and say, here's why it's not good for me. I don't have a car. I can't get there. It's on the other side of town. In my humble opinion, I don't know if the caseworkers, try and make it difficult to you on purpose. It's almost like they're trying to get you to fail. But, it's your family, so you got to do everything to make sure you don't fail that out-of-home placement plan, and that it is something that's good for you also. Keep in mind it is a legally binding agreement. So in closing, if an out-of-home placement plan is put in place, I recommend you follow it to the letter. I recommend you don't sign it unless it's for you. If it's a visitation plan, make sure it's only dealing with visitation and visitation only. Don't sign any blank forms for them to fill in later on. I recommend not complying with anything until after your 60-day trial, has actually been conducted and ruled against you in your favor. I recommend you don't take any drug tests whatsoever. Even if you're clean and you say, well, I want to prove it. No, they have to prove that you're a drug addict. They have to prove that you take drugs. So you don't have to prove you didn't. They have to prove they do. The burden is on them. So this is not the law. You can't talk your way out of this. So please don't think, oh, if I cooperate, if I do this, you can't. It's not the law. It's not the statutes. Once the ball gets rolling, once it's in court, it has to go through its process. So, keep in mind, you got to do things by the book. You can't comply with them or comply with all their services and think you're going to get out of it. You cannot engage in settlement negotiations. There are no settlement negotiations with it. Everything comes out as an admission. If you are selling it, then you're admitting to guilt. You're admitting you did it. Don't admit to anything. So that's why I say don't say, well, I'll work with you on services. Why would you work on services if you didn't do anything wrong? Why, just to get your kid back. Okay, I'll do it to get my kid back. No, I'm not doing it because I didn't do anything wrong, and you're going to give me my kid back. So make sure you obtain all the necessary documents, including copies of all your pleadings, all relevant notices to the parties. Make sure you keep copies, scan it, put it on your computer, keep it in a 3-ring binder. Everything that you get is very, very important. Make sure everything is in writing. Please, 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 please get everything in writing. Get copies of everything. The only way you can win this is to fight your way out of it, and it's going to be a struggle because they're trying to keep your kids because that keeps the cash register going. Once that 1-year cycle goes up, that 15-month cycle where they're no longer getting money, then they start changing their tune and trying to work with you all of a sudden. But your goal is to get that child back at 60 days, from the EPC to the trial. That's the disposition trial. Don't do anything otherwise. If you have any questions, talk to some of the other team members. Please read the state statutes. Please read this PDF handout that goes with this video series. You see, I've been a little excited and a little passionate about this episode because so many parents get jammed up on this, and I was one of them. And I'm trying to ensure that no one else gets jammed up. Go to your trial, stick to your guns. I wish I had done that. If I had done that, I would have had my kids back in 60 days instead of all the time. Make them prove that you did something wrong and go to trial. I hope this was helpful and of benefit. Thank you so much for listening to another episode of our Child Protection Video Health Kit series, and I look forward to seeing you in the next episode. Take care. Have a great day.